own law /134/25 between Professor Temi Abraka versus Lord D. My Lord, the parties are not court.
My Lord, the parties are in court. Appearance of authenticity.
May it please this honorable court, I am P.I. Adesanya, and with me here is O.O. Bamide. Our humble appearance is for the meeting.
May it please this honorable court, O.T. Quadri, and with me here is S.T. Odebode, appearing for the defendant.
My Lord, as a friend of the court, we were caught earlier on this morning before the court took a stand down. And with the kind permission of the court, it is necessary that both the litigants and their legal practitioners remember the proper ethics of this profession. And that is part of why we are here. So your Lordship will be kind enough to give us a few minutes to properly school them. One of such things repeated itself a short while ago. Parties were called and none of them answered. The court registrar correctly gave the Lord the position. Parties absent. Because we sitting there, we don't hear anybody making any response. These are key things that this profession or professionals must know what to do. So with your kind permission, if you have a few minutes, we'd like to let them know the proper thing to do when they appear at the court. You may proceed. Thank you, my Lord. Legal practitioners or the practitioners. One, it is not the court that will wait for you. You must be in court before the court sits. Go and read the valedictory services as to when His Lordship Honorable Justice Kayode Esho retired. The noble justices of the Supreme Court noted that the late F.R. Williams will be seated 15 minutes before the court sits. Court sits at 9 o'clock, not for the court to be waiting for you. It is unethical and improper of you not to be in court. The court already took a decision and decided to strike out the matter. If the matter had been struck off, that will be the end of it. How do you want your litigant to perceive of you or your client? Never in your life must you get to any court late. You know the time that the court will sit and you must get there on time. Now to the litigant. If you are not in court when your case is called, the court has the power to strike out the case, irrespective of the stage of proceedings. Now the court starts and you are not in court. It is not the dog, it is not the tail that wags the dog. It is the dog that wags the tail. And never must that happen again. You are practicing, you are learning to do the right thing, not the wrong thing. You are fast picking up bad attitudes. You have been put on notice as to the time that the court will sit. Litigants, you must get to court on time. The third segment of it is as to people who are also in court. You don't just walk in and out of court when the court is sitting. You know you have a business to conduct in the courthouse. It's a sacred place. You'll be there seated. And when you get to the court, you don't just go and occupy the front rows. The front rows are reserved for the learned souls. Dr. Mrs. Kolawole will be telling you this morning. Don't go to the front. The front row are reserved for the learned souls. You don't do this thing and then think it is proper. It is not proper. And again, when you are in court, learn how to be a friend of the court so that you can always ask for some things, some favor that the court can give. If the matter had been struck off earlier on, that would have been the end of the proceeding. And then, so what comes of all the preparation that you are doing? Who are not serious, who are not cultured, who are unethical, and who do not know what to do. It's not only me that will tell you what to do and what you have done wrong. I will invite Professor Uji also to let you know life is. And then we have somebody here also that will speak to you, also for just 2 minutes. He's an alumnus of this faculty. He had graduated from here several years ago, and he's doing very well. The company secretary and legal advisor of ENC. He will not know, not arrogant, humble, hardworking, forthright, never gets late to court. And then we saw some of you also coming here, not properly dressed. Hello.
To correct our students as regards conduct in court and conformity with the ethics of our very noble and sacred profession. We don't take the law just for granted in law. Now, let me start with the registrar. When you called the case, you said A, and then you use the word and. The word versus. Okay, the case is between A versus B. No. Once you use the case is between, once you use the word between, it must be between A and B. If you don't use between, you use the case is A, the case is, yes, is for A, the case is A versus B. Okay? A versus B have brought the case to court. Okay? So whenever you use the word between, what you use to qualify it is not versus, it is and. So that is as far as the registrar is concerned. Now, I will just buttress what Professor David said. Some time ago, both of us had the privilege of being schooled by the great Justice Bola Ajibola, and he told us of his experience at the World Cup that the culture there is not getting to court on time, but getting to court before time. So we are impressing it upon you, everyone, that you are not to get to court on time. Just like I said regarding late Chief F.R. Williams, you must get to court before time. Always waiting for the court and not the other way round. That is very, very key. Then at any time when you want to exit the court, while the court sits, or you want to you enter the court when the court sits, you must take a bow. You must always take a bow as a show of utmost regard to the honorable court. Then the litigants, well, those as you are the disputants. You are the ones that you are the ones that are fighting, quote unquote. So if you are fighting and you have submitted your fight or contestation, okay, to the court for adjudication, must you be hard, must it be hard that for whatsoever reason, like I said, having spent time, you spent money, you spent everything, you have expended energy and all of that, then you are not before. It does not well. So these are the few corrections we have now. We always have, it's a continuing thing. So we always give you correction. Once again, my Lord, will not take the indulgence for granted.
Thank you very much to the presence of the court for corrections that have been well spelt. I want to believe that I've taken notes of the corrections and are willing to turn a new leaf as we proceed on this matter. And I also want to say that you owe your clients the duty to be prompt, to be on time, and also the duty to defend accurately. So you should know that the court is a sacred house, and the rules of the court will always prevail. So please take note of that as we proceed.
Just to one point on this. Respectfully, yes.
We proceed.
Thank you very much for the indulgence. I haven't had the opportunity of addressing the courts in about 20 years. I had the privilege of passing through this institution about 32 years ago. I also had the opportunity of practicing advocacy practice. I was really enamored by that. I then stepped out of practice. So my own admonition to all of you today is going to be from the point of view of not what our distinguished professors have pointed out, but more from the point of view of what a client expects of you. Because as of today, I am the recipient of legal services provided by practitioners such as yourself. I'm assuming that many of you will probably have plans to practice. Some may have plans not to practice and go into maybe other things, become in-house counsel. I am an in-house counsel at the moment. Actually, I'll correct that. I used to be an in-house counsel. So I left legal practice. I used to work with an family, left legal practice after about 9 years of active legal practice, and then I worked in the legal department of MTN for about 12 years, and then I worked as the legal director and company secretary for Guinness Nigeria PLC for about 7 years. And about 2 years ago, I actually pivoted into what you can call now into the corporate world proper. So I am currently corporate relations director for Guinness Nigeria PLC. Now, what does a client expect of a legal practitioner? I think some of the examples have been shared today. You have to be, I think being prompt is even a given. So if I was the client and I came to court today and my lawyer was not in court as at the time the Honorable Court was sitting, I am not going to continue to use the service of that lawyer. Unless something that is life-threatening was the reason why that lawyer could not take it to court. So it's extremely important that you know that as legal practitioners, apart from being custodians of the law and also being the people who can advise your clients on what their rights are, what they should do and shouldn't do, there is also a certain level of service that is expected of you. Today we are talking about according to the Honorable Court the respect and the regard that it deserves. But then even to your clients, and just look at me as a potential client, you have a responsibility to be diligent in the things that you do. And part of being diligent is to, if you have actually prepared the case of your client today, and then you are not in court when the court sits, the case is struck out, that's the end of it. It doesn't matter whether you want the midnight oil. I'll pivot away from that briefly because I know the court is very busy and I do not want to take too much time. It's a privilege to have the opportunity to interact with you and to address you. For those of you who may not be planning to stay in legal practice, I am encouraging you. The foundation that practicing law gives to you thereafter. So please, do not say, oh, there's no money there, oh, adjournment, it's too stressful. I know many of you these days like the soft life. But you need the right foundation. Today, I can speak confidently because of the foundation that I had in legal practice. So I'm encouraging as many of you as possible. Spend time, especially in your service here, the first few years. You can choose to do something else afterwards, but the confidence that being involved in legal practice gives to you as a lawyer is not, you cannot discountenance it. And I'm encouraging you, put your head down, pay attention, learn, be diligent, be timely in all the things that you do, and I'm wishing you all the best in your endeavors. My Lord, thank you very much for the indulgence.
Thank you very much. I've noted all the corrections. It is right that you learn from all these counsels so that you can excel, you'll be able to excel in your practice in the legal profession. Either you choose to go into litigation or you choose to go through other branch. So let us begin the procedure. I want to believe that, or I should not believe, are all parties duly served?
Yes, sir. Yes, sir.
The plaintiff first.
Yes, my lord. It is served.
Defendant?
Yes, my lord. Yes, sir.
Okay. Just as an aside, you are supposed to tell us when you're served. As an aside. So let us proceed. Do we have any exhibits?
Yes, my lord. They have exhibits, but they said they are going to present the exhibits when it's part of the process.
The plaintiff.
My lord, the judges will be together
Can you call it on?
My lord, do not seek the indulgence of the court to render our escape. My lord, in compliance with the provision of section 84 subsection 4 of the 2011 Evidence Act, we want to render our first estimate, which is London's payment portal, which we have noted as Appendix 1, my lord.
Let's see if that is sorted for now.
Yes, my lord.
Any confusion?
Yes, my lord. Yes, my lord. The defense would object as to the admissibility of the documents tendered before it. My lord, while we were served yesterday via electronic mail, we got the debit receipt of the presumed debit receipt of the applicant yesterday as at 6:45, and we also got the presumed breach of intellectual property work of the applicants, and also the original work of the said applicants as at this particular port. Also, we got the presumed breach copyright work which the applicant said that they had obtained from the portal of the defendants. My lord, the objection is owing totally to section 84 subsection 4 of the Evidence Act as quoted earlier by the plaintiff counsel on the fact that we were not served this compliance yesterday, and per the case of Abubakar versus INEC citation 2020-12 Nigeria Weekly Law Reports, parts 1737, my lord, on the advantage and disadvantages of computer-generated evidence. The use of computer and computer-generated evidence is indispensable in the current period. Documents produced by computers are common features of businesses and all spheres of life, and more of people becoming familiar with their use and operation. For as much as it is very advantageous, it can be very disadvantageous, since garbage in, garbage out is always the result. When falsehood is trashed into it, it gives out falsehood, and when the truth is trashed into it, it gives out the truth. The provision of Section 84, subsection 4 of the Evidence Act concentrates on two methods of proof, either by oral evidence or by virtue of Section 84, subsection 1, that is the certificate of compliance in accordance with Section 84, subsection 4. My Lord, while we were tendered this particular evidence, we were not given the certificate of compliance as at yesterday. My Lord, I would also like to cite the case of IGP Bello, 2023, 1 Nigerian Weekly Report, part 1865, page 265. The court stated in this particular case that the conditions set out in Section 84 of the Evidence Act 2011 as amendment must be satisfied. My Lord, I would like this honorable court to take cognizance of the word must be satisfied before electronically generated evidence is admitted. This can be done either by oral evidence under the Section 84, subsection 1, or by certificate of compliance in accordance with Section 84, subsection 4. Further, I would like the court to take cognizance of the case of Abiodun versus CJ Kwara State, 2007, 18th Nigerian Weekly Law Report, part 10, part 1065, page 107, the Court of Appeal. My Lord, the court stated that the section of the Evidence Act are mandatory and non-compliance is bound to lead to the rejection of the particular document tendered before the honorable court. My Lord, the plaintiff in this particular case has failed to comply with the provision of the Evidence Act when it was tendering its evidence yesterday by electronic mail, and that's my submission, my Lord. That's the objection the defense would like to tender as at this particular time.
Documents that we are tendering as evidence, I am trying to figure out which is which as documents. Do you mind to state again which?
Which is Lolly's payment portal payment. Lolly's payment portal, which is appendix 1. Alongside the certificate of compliance.
Just a moment. Lolly's payments.
Payment portal.
Okay. Alongside
Certificate of compliance.
and
Professor Kenyola's notes, lecture notes.
Professor Kenyola's lecture notes.
Yes, sir. Which bears the watermark. Professor Kenyola's
Marked as exhibits D.
also, my Lord. Professor Kenyola's plagiarized content, my Lord.
Marked as exhibits any exhibits by the defendant?
Yes, my Lord.
So, can you tell the court on all the exhibits listed so that the plaintiff can contest it?
Yes, my Lord. My Lord, we would like to tender this particular exhibit to this honorable court. The first being the payments made by the lady to the site host operator for the maintenance of the site. I have given it to the court registrar, sir. I would like to tender this to the court and mark it as a particular exhibit. Also, tender is number one, the screenshot of the payment portal and the accounts it goes to, that being the site operators. My Lord, the second is that copies of reviews of the users of the blog spot saying that the material was easy to read and understand while making reference to the original work of the plaintiff. The third is other works of other lecturers which has been put on the blog spot and commendation by them on how it was made into precise, short to use by people who are even non-law students to read and understand. My Lord, we've tendered this as exhibit on this particular court, honorable court, and they have complied with the provisions of the Evidence Act.
Any contention by the plaintiff?
All right. In accordance with the provision of section 84, subsection 4C. My Lord, the judges will My Lord, this provision provides that dealing with any of the matters to which condition mentioned in subsection 2 are going to relate, and purporting to be signed by a person occupying a responsible position in relation to the operation of the relevant device or the management of the relevant activities, as the case may be, shall be evidence of the matter stated in the certificate, and for the purpose of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. My Lord, in the certificate of compliance tendered by the defendant's counsel, it wasn't stated that anyone that has a responsible position made the certificate of compliance, my Lord. And as regards this, my Lord, the certificate of compliance in compliance with section 84, section 4 does not meet the requirements of the provision, my Lord.
All matters relating to the admissibility or the inadmissibility of the documents will be addressed. All right. All the exhibits have been all the exhibits tendered by both parties are admitted. So let us proceed. The defense counsel.
If it pleases this honorable court, OT Quadri, appearing for the defendant again. My Lord, I would like to first give a brief overview of the case as well. This is a case of copyright infringement situated by Dignity Professor Penny Abraka of the Central University against Lolly, one of his students in the university. My Lord, the legal disputes are as follows. Number one, whether a national slow down. Thank you very much. As the court pleases, my Lord. Number one is whether AI2 can be held liable for plagiarism. Number two being whether or not lecture notes do merit copyright protection. And number three is whether or not the breach of academic integrity in AI generated content. My Lord, I would love to move further to the statement of fact on this particular case. Number one, the current course of action has arisen between Professor Penny Abraka, Dignity, and the law student, Lolly D. The comprehensive lecture notes titled Intellectual Property Law is a university teaching material written by Professor Penny Abraka, a law lecturer of Olamide University. Number three, the lecture notes were written for the instruction of students in the university who were studying intellectual property law. Number four, Lolly D is a law student who operates a blog for explaining legal concepts to law students. He has been uploading the content since his 200 level years and now is in 500 level. Moving further, my Lord, Lolly D operates his personal blog through the website blogspot.com, a website that hosts operators and allows them to post their content in return for a fee by the visitors to the blog. Moving on further, my Lord, the fee paid by the visitors give them a daily access to information contained in the particular blog. And the court I would like the court to take note cognizance of the fact that no portion of this fee is received by the operator of the blog, that is Mrs. Lolly D, my client. Moving on further, Lolly D made use of an AI-powered tool to paraphrase, rephrase, and question this particular material. He then went on to put this on his blog he went on to put this on the AI-powered tool. However, when the AI-powered tool was putting this on the blog, it forgot to put on citation. My Lord, I'll move on further to the fact that Professor Penny Abraka then discovered the content through a Google search. She attempted to access the documents, but she was asked to pay. Following this, she instituted instituted the action against Origi for copyright infringement, breach of academic ethics and standards. My Lord, it is easy this honorable court. I want to move to the summary of arguments, my Lord. The first summary of arguments is
How long you have? Just 10 minutes to summarize.
as the court pleases. The first being whether or not AI too can be held liable for plagiarism. My Lord, I would like to defer proceedings to my co-counsel to take the first issue while I take the second and third issue for determination.
My Lord, as to the first issue, whether or not AI tools can be held liable for plagiarism, my Lord, the defense would like to answer the negative. My Lord, AI tools themselves cannot be held liable for plagiarism and copyright infringement because they function as assistive technology other than autonomous creators with legal responsibility. My Lord, plagiarism and copyright violation require an element of intent and direct action, which AI tools lack since they operate based on user input and algorithm processing without independent volition. My Lord, furthermore, the fair use doctrine stipulates that the idea that AI assisted paraphrasing can transform content sufficiently to avoid copyright violation. My Lord, based on these issues, we end the following argument, my Lord. The defendant has based his content on the AI-generated paraphrasing of the lecture notes of the printing. My Lord, the AI tool significantly paraphrase, rephrase, and evidently transform the work of the printing into an entirely new purpose of the work. My Lord, the negative AI works by identifying the patterns and structures within existing data input to generate original and new content. My Lord, AI tools function as assistive technologies designed to help users process information. In this case, my Lord, AI systems do not inherently engage in direct plagiarism. Rather, they allow the user to reproduce. They don't allow users to deliberately reproduce original work without modification. In this case, my Lord, an attempt was made by the defendant to rephrase the original work and paraphrase it without the intent to significantly alter it. My Lord, I would like to refer this honorable court to section 20, subsection 1C of the Copyright Act. My Lord, this section provides that the rights conferred with respect to the work under section 9-13 of this act do not include the right to control any of the acts specified in those sections by way of field dealing for purposes such as non-commercial research and private study. My Lord, this is the statutory basis for the doctrine of fair dealing under Nigerian law. When it comes to AI-related content, the court considers four tests to determine fair use. My Lord, these tests are provided under the proviso of section 20 1 of the same Copyright Act. And these four tests are, my Lord, the court will consider the purpose and character of the usage, the court will also consider the nature of the work, and also the amount and substantiality of the portion used in relation to the work as a whole. And also, finally, the court will consider the effect of the use upon the potential market value of the work. My Lord, moving on, my Lord. I would like to establish the doctrine of the transformative view doctrine. This doctrine is an element of the we would like to take that discuss the doctrine of transformative views.
You have 3 minutes more.
Okay, sir. This transformative view doctrine is an element of the fair use doctrine. It explains that fair use based on the incorporated work. If another person uses the incorporated work in a different manner or for a different purpose from the original, and that this does not infringe on the older's copyright, where the transformative use adds new expression, meaning, or message to the original work, it is more likely to qualify as fair use other than non-transformative copy. My Lord, we would like to refer this honorable court to the case of Authors Guild Incorporation versus Google Inc., Authors Guild Incorporation versus Artist Trust, and also Perfect Ten versus Google. This attention to required, my Lord. In one of these cases, my Lord, Justice Suta stated that the more transformative the new work is, the less it will be significant for other factors like commercialism that will weigh against the finding of fair use. My Lord, this decision was held in the case of Campbell versus Aki-Frost Music with citation to required, my Lord. My Lord, the defendant is submitting that an AI power tool cannot be held liable for plagiarism. The issue is on the question of whether training a generative AI tool on a copyrighted work infringes on the reproduction of whether it infringes on the original work or it is double fair use. My Lord, the defendant is are very that the use of generative AI cannot be deemed to be plagiarism. Rather, it is a fair use of the copyright tool. My Lord, we will be concluding with the scholarly work of Matsad and Pamela Samuelson, who are AI experts, who wrote in the article that the training of an AI system on purported content is transformative use, and therefore, as you have already stated earlier, the use of purported work in a transformative manner will not directly lead to plagiarism. Rather, it will be deemed to be the fair use of the original purported work. My Lord, I'd like to defer proceedings on the original, remaining two legal issues to my co-counsel.
Your counsel, your time is up. You have 50 minutes and you have exhausted your 50 minutes.
I would like to say, I would love to appeal to this honorable court to kindly grant us a little bit of time to address issue 2 and issue 3 succinctly within the shortest period of time.
Court can only give you 2 more minutes.
Thank you very much. Under copyright protection, whether or not mention no merits copyright protection, my lord, the difference answers in positive. That's copyright protection. Mention note 2 qualifies as copyright protection. This is pursuant to section 1 of the Copyright Act. The defense of the objective of the act, which are to protect the rights of the authors, to ensure that their intellectual property rights are well protected. My lord, this is stipulated in page 6 of the memorial submitted before you. I would love to move on further to section 2 of that same act, which provides that work shall be eligible for copyright, which includes the literal work of every author. My lord, I would love the court to take cognizance of paragraph 8 of section 2, which stipulates that for such work to qualify as a work copyrighted, some efforts must have been expanded in making such works to give it an original character. My lord, in the case of Abad versus Basfar, citations duly provided states that it is impossible to define what fair living is, but it must be a question of degree. Moving on further, in the case of Dudley versus Highnessly, citation duly provided, the court stated that no certain line can be drawn to distinguish a fair arrangement, but every case must depend on its own facts. My lord, I would love the court to take cognizance of section 20 of the Copyright Act, which stipulates the provisions of where an act, a work can be said to be fairly used. And like my co-counsel previously stated, the purpose of the character must be seen, the nature of work must be seen, the amount and sustainability of the work must be seen, the effect of the use of that particular work must be seen. In the instant case, the defense argues that the purpose and use of the literal work was to educate students of intellectual property and make the lecture use as subtle as possible and very detailed for Nigerian students to understand. Further, the nature of the work was not for commercial purpose for the students to benefit from, while the work was inputted into AI-generated machine and it has transformed the work. Further, the defense contended that she had fulfilled the provision of section 20 of the Copyright Act, which stipulates that the work must be used in a fair way without infringing on the Copyright Act. And this provision basically states that if you use a copyrighted work fairly, you do not need to seek the authority of the original user. My lord, the first context that in the case of Peter Obey versus Grapevine Communication Limited, citation being provided, which states that the proper acknowledgement of the author's work and the title of work is crucial in claiming defense of error. The defendant had fulfilled this criteria, but did not intend to flagrantly disregard the rights of the order or of the author. Further, that the payment being asked for in the blog site was for maintenance of the site by the host operator, and that no money must be remitted to his personal account. And in fact, the defendant has also paid annual fees to the site operators, like the that can be seen in the evidence standard before you, my lord. Based on the argument canvas that the defense then submits that the work published on the blog site was for fair use, and that Lord indeed my client herself also pays remittance to the site operators for maintenance of the site, and that the fact that 15 naira being paid to every user of the site goes to the site host operator and not to Lord's personal account. My lord, on the third issue of academic integrity, whether or not the conduct constitutes a breach of academic integrity, my lord, as the court policy.
My lord, without wasting the time of the
You have 50 minutes to address the court.
my lord, I will be addressing the merits of issue 1 and 2, and my co-counsel will be addressing the merits of issue 3, my lord. My lord, the first issue is whether an AI should be held liable for plagiarism. My lord, in answering this can be held liable for plagiarism. My lord, to begin with, artificial intelligence refers to the techniques, machine, system, and application programmed to perform individual tasks. On the other hand, my lord, plagiarism has been defined by the learned Honorable Justice K.D. Kamila in the landmark case of Dr. Onijide Ajisafe Akiba and Federal University Oye as literal text, choosing the work of another author with an intent to deceive the public that it is your work by failure to obtain permission or to acknowledge the other author, my lord. My lord, in order to convincingly establish that AI can be held liable for plagiarism, my lord, the plaintiff shall advance arguments from two standpoints, my lord. To wit, for the first standpoint, paraphrasing the original work of an author. Paraphrasing the original work of an author constitutes plagiarism. And the second standpoint, my lord, AI through its users and programmer can be held liable under the law for plagiarism. My lord, on the first standpoint, the plaintiff argues that the defendant's act of paraphrasing the plaintiff's lecture's notes without acknowledgement of the plaintiff as the original author of the work is plagiarism, my lord. My lord, it is a well-established principle that the rule against plagiarism is violated by copying intellectual output in any form or manner, even with the author's consent, my lord. My lord, in this instance, it is clear that the defendant act of intentionally paraphrasing the plaintiff's lecture's notes constitutes plagiarism, my lord. My lord, a thorough comparison between the plaintiff bill 405 and bill 415 notes and the defendant's electronic text revealed that the content is essentially identical with only minor paraphrasing. My lord, on the second standpoint, the plaintiff argues that the AI tool, through their user and developer, are liable under the law for plagiarism. My lord, the plaintiff made the submission under the principle of vicarious liability. My lord, as urged by the learned justice of the Court of Appeal in the case of Bello and Dauda and others, my lord, vicarious liability means liability that is supervisory party bears for the actionable conduct of subordinate or associate because of the relationship between the two parties. My lord, the plaintiff relying on this principle of vicarious liability argues that the action of both the user and the programmer of this AI raised to legal responsibility, my lord. My lord, accordingly, both the programmer who designs and trains the model and the user who supplies prompts leading to the infringing output occupies a supervisory role. Given this, my lord, it is reasonable to foresee that AI will generate a plagiarized response, thereby rendering both the programmer and the user liable for resulting infringement. My lord, applying the above well-reasoned principle, it is clear that the use of ChatGPT developed by OpenAI and used by the defendant is liable. Thus, on this first issue, the plaintiff submits that an AI can be liable for plagiarism. My lord, I would love to proceed to issue 2, my lord. My lord.
7 minutes.
Thank you, my lord. My lord, issue 2 states that whether lecture notes merits copyright protection. To this imperative question, my lord, the plaintiff answer is positive. The plaintiff strongly contends that lecture notes, as in this case, the plaintiff merits copyright protection. My lord, in a bid to address this statement above, copyright has been defined in the case of Ubon versus Globacom Nigeria Limited by the Supreme Court. My lord, citation duly provided in footnote 11. We humbly refer the Honorable Court to paragraph 522. My lord, by the position of our jurisprudence, it is clear on the works that as copyright has been provided. My lord, the plaintiff also contends that under Nigerian law, a literary work does not require registration in order to enjoy copyright protection. This was affirmed by the learned justice of the Court of Appeal in the case of Nigeria Breweries PLC versus Emmanuel Nweke, my lord. My lord, the plaintiff vehemently argued the condition provided in Section 2, Subsection 2 of the Copyright Act 2022 that the plaintiff lecture note is eligible as copyright, my lord. My lord, we love
4 minutes more.
all right, my lord, assuming but not conceding to the fact that the defendants raised the issue of fair dealing, we state categorically that the defense of fair dealing will not avail the defendants. My lord, this is because the plaintiff did not use the plaintiff lecture note for fair dealing, my lord. In accordance with the provision of Section 2, Subsection 2 of the Copyright Act, duly cited, my lord, which provides two conditions for a work to meet before it will be eligible as a copyright material. The first condition is that it must be an original work and it must be in it must be fixed, my lord. My lord, this work was originally created by the plaintiff and also it was fixed in a PDF format, my lord. My lord, thus on issue 2, the plaintiff strongly submits that the lecture note merits copyright protection as they fall under literal work under the Copyright Act, my lord.
I got that for 2 minutes.
On issue 3, my lord, whether they can exist a breach of academic integrity in the context of AI-generated content and what constitutes it. My lord, to this particular question, the plaintiff responds in positive, my lord. The plaintiff contends that there exists a breach of academic integrity by the use of artificial intelligence generated content in academia. My lord, without missing what constitutes academic integrity means acting with the core value of honesty, trust, fairness, respect, and responsibility. As a general principle, my lord, the academic integrity is the central principle on which the academic community depends, and when violated, it undermines the credibility of the academic body and further devalues the reputation of the school and reputation of the individual. My lord, without the core values that constitute academic integrity,
what I would call this between Professor Tenya Braka and Lord D. And just to note, this is some sort of academic exercise, and we are not here to determine whether there is a winner or there is a loser. So what I'm basically going to do is I am going to address all that you have presented before the Honorable Court, and also give opinions as to the use of AI-generated content, especially as it relates to plagiarism, and then to also give final comments. So first, I want to appreciate all parties for your work, for your research and coming up with brilliant thoughts. I also want to commend the counsel both on the plaintiff and also on the defendant. As I've mentioned, this is not to determine whether the plaintiff has won or the defendants won. First, I want to first talk about some of the things that you have worked on and the argument. The both parties, which is not a matter for contention, both parties acknowledge that the point of contention is not whether a lecture note is copyrighted or not. That is not the both matter. But I observed that in your work, for both parties, I observed that while doing most of the citations, you cited more of blog posts. For instance, the party cited Wikipedia, and most of these sites would just be best for information, but to some extent do not give some scholarly credibility for academic work. So it's something you would do more. I observed I did not see any form of referencing published materials. I know that in the current landscape, the legal landscape of Nigeria, which relates to AI-generated content or artificial intelligence, you might not see so much. You might see little or no, precedents. So in this instance, you might opt for secondary source of law, which could include either rulings by other jurisdiction, referred to either dictionary or even articles and publications, which in most cases are not bad, right? I also observed, I addressed this as to the content of the work. I observed that, for instance, in a particular the copy of the brief I received by the defendant does not have suit number. I know that there might not be generally acceptable. There might not be suit number provided beforehand, but it is part of the structure of a legal. Part of the component of a legal document to have suit number, which I actually did not see. I agree with the references you have made on copyrights and the copyright law, the existing copyright law, as to fair use. But then let us dive into some of the some of the questions for contention, and I find it very, very interesting. So we have three questions for contention in this matter: whether AI tool can be held liable for plagiarism, whether lecture notes are eligible for protection, and what constitutes a breach of academic integrity in the context of AI-generated content. So I would speak about these questions one after the other, and I will also rely on some of the documents, some of the citations, the legal precedents, the judicial precedents you have cited in your work. I know that there is a lot of ambiguity as to AI generated content. And I want to start with one of the most respected one of the most cited definition of artificial intelligence and what constitutes as artificial intelligence, and then we'll also go further to look at what constitutes as an AI in this context, mean artificial intelligence, what constitutes as an AI generated content, and then to also go ahead to look into liability of AI generated content. So, according to the OECD, which is the organization for according to OECD, which is the Organization for Economic Cooperation and Development, they define AI system as a machine-based system that for implicit or explicit objective infer from the input it receives how it generates outputs like predictions, content, recommendation, or decision that can influence physical or virtual environment. I want you to note that this definition has been globally recognized and also have been adopted by international instruments such as the G7, the G20, and even the Hiroshima AI instruments. Also, the particular definition has also been adopted by the EU, European Union AI Act, and also have been adopted by the Global Partnership on AI. So I would want to rely on this definition for us to proceed with this rule. So I will read the definition again. So an AI system as a machine-based system for implicit and explicit objectives infers from the input it receives how to generate output like predictions, content, recommendations, decisions that can influence physical and virtual environment. By this definition, we could infer or we could draw a conclusion that an AI as a tool does not own, neither does it have the content, rather than the content that it has been trained on. But let us, deep dive into the legal recognition of AI as an author. Generally, AI tools are considered as means of production. If a person uses AI to generate content, authorship may depend on the content of human involvement, such as the prompt design, the editing, or the curating. Let me go again. Generally, AI tools are considered as means of production. If a person uses AI to generate content, authorship may depend on the extent of human involvement, such as the prompt design, the editing, and curating the results. So in this instance, we also need to know that, let me read also from the opinion of Creative Commons about AI-generated content. It states that AI-generated work may lack protection under traditional copyright law. In this case, the Copyright Act. Attribution should go to the human responsible for editing and curating the outcome. On the subject of the legal personality of AI, because currently by Nigerian landscape and avalanche of legal and judicial precedents, only a person, either natural or corporate, can sue and be sued in Nigeria. It means that to determine whether an AI, an artificial intelligence, can be sued or liable for any sort of responsibility in the current legal landscape of Nigeria is still a no, because there is, as at now and as it exists, only a person in law, a person known to law, can sue and be sued. But I want to read some opinion of experts on the question of attribution of AI-generated content. I would read the opinion of Professor Avid from Princeton University on the question of why do we even cite? Because it's a question of contention here. Why do we cite? It states 3 reasons why we cite. The first is to show that the source carries some sort of epistemic authority. This isn't necessarily because of author, but because of our trust. That means trust of the body or the persons using the material. Number 2, to credit the source. And number 3, to ensure traceability. Also to note that they are a fixed form of records of idea. In this instance, neither does any of these 3 apply to an AI. The first is that AI-generated content does not have any sort of epistemic authority, neither does it credit the source, and neither can it be traceable. Also, the proper thing to do, according to him, when using an AI source, AI content or anything, irrespective of the extent or level of human involvement, is to disclose. And the reason for disclosement is for transparency, rather than citing for attribution, credit, or even signaling credibility. Some scholars, they also believe that citing an AI tool is equal to citing the entire internet. And the output of a large language model is a synthesized distillation of 1%, right, of a massive body of work, and omits subtext, and disclosure is often pertinent. Also to note that an AI or a chatbot contains a contextualized representation of knowledge. Looking at all the above, it is right that the citing or the use of an AI-generated content, either you are paraphrasing, irrespective of how it is being used, it strikes that there is some sort of attribution to the original author. In this instance, there is no argument as to whether the Mrs. Lolly, in this instance defendant, either attributed or cited whether it is us or it is for the professor. I mean, it was not contested yet. And section 20 sub 1 of the Copyright Act. And from all, this, you can bring out 4 elements, right? 4 factors to determine whether an act, constitutes as fair dealing. The first is the purpose and character of its usage. The second is the nature of the work. The third is on the amount and sustainability of the portion used in relation to the work as a whole. And the fourth is on the effect of use upon the potential market or value of the work. In this instance, it has been proven by both parties that the defendant's nature of the usage of the material is just for educational purpose and is not to accrue any form of economic value to herself. I also want us to note that the defendant in this case attributing the liability of this AI-generated content is, on the AI tool is not known to the Nigerian legal system because an AI tool cannot sue or be sued. It would have been a different case if the liability of such act is either pointed to the user or pointed to the company that the parent company of the AI tool. I have also addressed what constitutes a breach of academic integrity in the context of an AI tool, in the context of an AI-generated content. And what the law encourages us is whenever there is a reason to use a particular tool for any AI tool, particular material for any AI tool, it strikes that there is proper attribution of the content and not just putting it out and claiming it as yours. Claiming it as yours is fraudulent and is not encouraged. But notwithstanding, I want to applaud both parties. I want to applaud both parties, and I have been fascinated by your arguments. I know that you have few questions to ask, probably something that have not been addressed as I mentioned, this is not to determine whether there's a winner or there's a loser. But if you have a particular question, I want to just leave it open. You have a particular question as to any issue related to the fair use of AI-generated content. And to be sincere, right, the question of attribution, watermarking, referencing, and copyright of IPs, intellectual property of AI-generated content, is still something that is very torn all around the world. In fact, recently there is a particular air company putting it out, publishing that if there is success, if the parties that are prosecution against them for intellectual property, if it succeeds, they will be to the depth of over $730 million US, to pay. So it is still something that is still turning, and different judicial systems have tilted to different angles as to whether I know that we are the topic before the court is not even as to the eligibility of copywriting and AI generated content. It is not an issue within the court. It's not a matter of consideration, but it has been, there are several contentions whether a person can patent as his own materials that are AI generated or not. But as it stands, the current stand is to determine the level and the extent of the input of the party involved. What input, what extent of work have been imputed in that content? Is it just solely AI generated, or is it something that you used and you added a large amount of work to make it a work of art? Because what the law wants to protect in copyright is to protect that original work, the works of author, works that have been, the hard work of somebody, which is the author, is not claimed by another person, which is fraud. But I also want to give room to the friends of the court if there are few inputs, on this matter before we allow other comments, questions from the parties. Any comments from the friends of the court as to the matter, at hand?
Thank you, Lord. It's like the court has clarified on the matter that has been done. The court has told us that this is not a win or lose matter, but it's an opportunity to x-ray the principles and practices of the law. Artificial intelligence, electronic evidence, copyright issues, constitutional angles to it. So if you have anything that you like the court to address, particularly from an expert. For those who are present yesterday, you will collect that we had a very wonderful session yesterday. Perhaps it was not mentioned yesterday. His Lordship today, when he was in real active practice, still in active practice, looked at a section of the Freedom of Information Act. He felt something was wrong with that section, and he took an action before the federal court. And of course, the ruling went the other way, but it was posted online. And an American university saw it, and he contacted the Lordship. Are you sure you are the one in this matter? Can you send us a certified copy? Which was done. And then they said, you have a valid US visa, and it was shortlisted for a global competition. So he did not win that competition. He was among the first four best four. Yes. And as a result of that university gave him part-time lecturing job. So you have a unique opportunity. If there's anything you'd like to ask, and of course we cannot do the opportunity add and finish. But if you think there is nothing you want to ask now, you think about it, you can always, as a body, pull your questions together, send to His Lordship, and when the results come, you won't have the benefit of drinking from that cup of wisdom. So if you have anybody who has anything, ask it. Yes, 1, 2. My Lord, they are just 2 of them.
My Lord, to the best of my knowledge, I need clarity on this. Who should be held liable for copyright? Is it the AI company or the
presently, I'm working on my long essay, and that's basically the topic of my long essay. Like, who should know AI generated? Should it be the AI? Should it be the developers? Should it be the users that are putting the prompts? Or should it be in public domain? I just want to know your opinion.
Alright, liability of copyright when it comes to AI generated content and a thorny issue, and it's a question that I'm asked by most scholars. If the user should be held liable, if the model should be held liable, which in most cases cannot, if the companies would be held liable, or if the developers would be held liable. To answer this question, we would borrow principles from existing principles of law, from jurisprudence, from basic principles of thoughts, and also from corporate law, so principles of corporate law on matters of lifting the veil of incorporation, and that is when if there are liabilities, most times criminal liabilities, when you crack the shell of incorporation to know who are those behind it, to know who are those behind it. We need to know first of all to understand, for us to determine who is responsible for AI generated content. There are a few things we must consider, or who is responsible for the liability of AI generated content. There are a few things you must consider. Number one, you must consider the extent of the wrong, right? The extent. For instance, if a particular IP, if a particular IP was copyrighted, and you want to know to what extent is it that it was copyrighted as a whole? Is it that it was copyrighted in part? The second thing is who is the user, to what extent is he using it? Right? If the user is using it, for economic purpose, and then you also want to know if the user, has claimed it as his own or has attributed it to AI model. Because unlike it is in the US, where the court had, flagrantly refused the copywriting of AI-generated, material. I say it is not copyrightable because it was looked at as not human-owned. So you have to understand what is the extent of the input of the person, and then what is the extent of the damage. So some tools, right, are expressly used by an AI company, probably at the time at which they were training the model. In such an instance, the company will be held liable, and that is what is currently the stand globally. You will see several suits against, big tech companies, OpenAI, and so on. There are several suits against them because the model, the company, while training their model, used the material, used copyrighted material to train their model. So you categorize that as the liability from the company angle. But then, if a user picks up a copyrighted material, feeds it into an AI tool, generates a result, and attributes it as its own, in that instance, you will know that that is the user-induced piracy, and the user will be held liable. But what if, in the instance where a user uses a model, generates, content, and attributes it as its own, and most times it is very difficult to even determine, because if you want to attribute a material, you must be able to know who owns it, right? You must know where was it published, when was it published, for you to be able to properly reference it. When using some of the tools, you don't know the user, you don't know where it was published, you don't know whether it's copyrighted or not. In that instance, what the court would look at is the court would look at the circumstances, and they would give rulings based on the circumstantial evidences, right? The proofs that have been put before the court. But on the second question, as to who should own a copyrighted material, and this is also a global contention. Some have asked whether if the user should own it, if the company should own it, if it is for the engineer, or even if it is for the tool. But you see, there are still contentions as to it, because the argument from the company is that they trained the model based on publicly available information, and this instance they made it public, right? On the aspect of the user claims that I am using a tool and I did the work. The work in this instance means I prompted it, I refined it, I edited it, and I published it. But irrespective of the claim, who should own or who should not own, it is still in the court position based on the circumstances of the case to really determine it. Because most times, some data are synthetic. What do we mean by synthetic data? Synthetic data are data that are generated through several tokens. So for instance, just the way we speak our language, AI tool has the ability to put dictions together to form languages, and also to probably infer based on, because I made a definition that an AI tool is able to give predictions based on trained data. So in those instances, the predictions that have been made are what we refer to as synthetic data. Now, if a data is synthetic, the synthetic data is not something that could be attributed to any author, because they are data that I would say the authorship is lost in transit. Based on several trainings, annotations, and several processes. So you lost the authorship, in process. So in that instance, anybody that is claiming ownership of such material must, present evidence to show that the material or the particular content that are generated belongs to him or closely resembles what has been copyrighted. Did I answer your question? So what we look at is whether the document is in its original form or it is in its synthetic form. Original form as picked word for word, or synthetic form as being refined and leaving its original state. And then what original form and synthetic form, bringing it together to compare if it actually resembles either the work of the author or closely conveys the idea at which the work of the original author conveys. So depending on the circumstance, the court actually gets to decide whether it falls on the author as being liable or owned, or it falls on the user, whether they are liable or they own the content. But notwithstanding, I would say that also say that I want to commend, the work of both parties. I understand that it is between Libu Magnet and Inatempo.
So I don't say that you can ask questions. I have questions. Okay, so my question is as regards the copyright and AI also. So I want to ask, I think some problem is to arise in two ways, in the input stage and the output stage. In instances where we have LLMs, such as the AI train their models on copyrighted works. In that instance, copyright issues arise in that instance, and also in the output stage also, when the user probably gives the model the prompts, and the model makes use of those input that it has received from all those sources to generate the prompt. I think this issue was exemplified some time ago when some authors in America, like John Grisham and when they brought an action against, I think, OpenAI for copyright infringement, because some users generated some content. They asked just the next question to create novel ideas, and the OpenAI model, I think, was trained on the books of those particular authors, generated content that was similar with that mission. So I think my own question now is that in that kind of instance now, where in the output stage and in the input stage and output stage, who would be liable?
In the input stage and the output stage, I think I have somewhat addressed it, where I said that whether it is trained on a copyrighted material or a user imputes the copyrighted material. So in that instance, you can also see that as the input and the output, right? Just in your context, where because by virtue of training the model through the training stage, either any form of learning that is going to be either supervised or unsupervised. Most of those things are they tend to not, they tend to be unlabeled, right? They train those data they train them on unlabeled data. So in that instance, the liability of such would most likely fall on the company, because they are the parties at which they are the persons training the model, and they are the human agents. I think that's what they are, the human agents in this case, right? But in the case of the user, where it's a user that puts the prompts, most likely imputes a data, in fact imputes a document, and the AI generates the content based on the document, right? In that case, you have to, what the court would likely resort to is to hold the user liable, because it is the user that prompted, that led the AI into bringing it. As I mentioned, an AI cannot be liable for anything. An AI is just a tool. It responds to any prompts that the user uses for it. And AI is just a tool, and not the other way around. So, as I was saying earlier, I want to commend the work of both parties. I learned it is the legal magnet and the inner temple that are both the parties in court, both the defendant and the claimant. Am I correct? Yeah, so what I actually want to emphasize is I back in those days while I was still in school, I know of how most persons have decided to be neutral, either going for inner temple or legal magnet, because of the unhealthy rivalry that was going on between both parties. What I just want to to admonish, either the inner temple and the legal magnet, both parties that are present here, is the benefit of peaceful coexistence. I want to know that either you are inner temple or legal magnet, everything starts and ends in school, right? You can still be saying you are an alumni, or you used to be a member of legal magnet, used to be a member of inner temple. But at the end of the day, we all have things to benefit from each other outside the four walls of the school. So I want to encourage you to continue the peaceful coexistence. I deliberately did did not want to plow through the route of delivering judgment that Inatepo have won, legal market have won, and then start claiming who is superior, Inatepo or legal market. We do not want that. We do not want that. We want peaceful coexistence. And I've mentioned this is an academic exercise which we want to know, the extent of your understanding of court process, also the extent of your ability to legally, to argue matters, and also to see your confidence in addressing the public. So those are the things that we are actually looking at in this matter, and I want to appreciate everything that you have all done, and that is the ruling of the court.
And God bless you.
And today is 7th of May 2025. We are having the exhibition of our faculty research projects. And today our students have also had the Moot court trial at the Oluwasegun Law Research Center. We are just talking about them. And so please, can you follow me in there so that we look at the various works that we have. You are welcome everyone. I want to thank you once again for coming. And this is our vision statement and our mission. Now, the Faculty of Law at Oluwasegun University was established over 40 years ago, and from this great research citadel, because it's a research citadel indeed, we have had many alumni who have excelled in various fields of life, in the academics, in the corporate world, in litigation, and these are the last count. We have not less than 4 SAN, if I'm not mistaken, maybe more than that. And we've had distinguished professors who are also learned SAN. We have had judges and magistrates. We have had very different many levels of persons who are in the corporate world. For example, one of our who came all the way from Lagos is a corporate director for Guinness Nigeria Limited. I'm sure when you hear Guinness, you know what that means. And so today, we start with our vision statement. Our vision statement is for this faculty to be a school of law first reckoned in Africa and one of the very best in the whole world. Our mission, therefore, is to demonstrate teaching and research with attitude so that we can produce high-caliber law graduates who will prefer cutting-edge solutions to present and emerging human problems. So, and that is why we took as a theme of our research AI, which is artificial intelligence in legal education and legal practice. Our philosophy is based on human intelligence. We want everything that will be for illustrious sons and daughters of Nigeria and also the whole world to be from our own end, to give back to the society, to involve ourselves in pervasive and innovative teaching methodology, so that by the time our students go out of this place, they are acclaimed, they are high quality, and they are very, very employable. And to that extent, the faculty has also produced many products, and that is what we have showcased here today. And when you look at this particular box, a shelf containing our products, all the products that you are seeing here are produced by this faculty, whether jointly by our lecturers or by the students also, and also some of our learned colleagues who have co-authored with us. For example, we have the Faculty of Law Journal, which we name the Olabisi Onabanjo University Journal. Yes, this was on years back. This is a January 2009 edition. And there has been a paucity in the publication, not just because of funds, but also because of the policy that we have in Olabisi Onabanjo University. But then we are hopeful that sooner than later we will be able to resuscitate these journals. The public law department has also been in the forefront of producing journals, and that is the Journal of Public Law of Olabisi Onabanjo University. It's a 2011 edition, and the same reason I gave about the Faculty of Law Journal is also the same for this particular one. Again, we have had our illustrious lecturers going through so many other things and then publishing work which has been for the edification of our people. For example, this Milestones on the Bench was edited by Idowu Adepite, an associate professor of this faculty, and also Professor Olusegun Oluyide. It's an essay in honor of Honorable Justice Mobolaji Ayodele Ojo, and this was published in the year 2023. Again, we have a renowned expert in the field of law, especially family law, and that is our own professor, now retired, Professor Mojisola Ogungbe. Mojisola Ogungbe, Prof, our mother, let me even say our grandmother, actually published this book some years back, and this was in 2004. And this is a valuable one. It's family law through the cases. Our students are still recommended to go through them and buy them. Again, when Professor Mojisola Ogungbe was exiting this university as a professor upon an attainment of the age of 17 years, the faculty came together and put down this particular Readings on Matrimonial Dispute Resolution in Nigeria. It's in honor of Professor Mojisola Ogungbe, and it was edited by Professor Olusegun Oluyide. Virtually every lecturer in this faculty contributed a chapter or more to this particular one. And then we also have our own Mr. Jide Omushaki, the Jagaban of the Faculty of Law, also having some monographs in respect of dictionary, legal dictionary, and also illustrations and hints on legal writing. We have again some of our lecturers coming together to publish this particular book called Rights. In it, you will see so many things containing your rights, what you have to do to also assess enforcement of your rights is contained in this particular book, edited by Olusegun Oluyide and Mr. Olu Awolowo of blessed memory. May so rest in peace. Amen. Then, last but not the least, because I don't want to take our time so much, we have this all-encompassing products from Professor Olusegun Oluyide. This product is just please setting, is 1,343 pages. It scans through 3 different courses in this faculty. Land law is here, law of trust is here, law of conveyancing is also here, and is an edifice. Is a model text for any of those courses that I have spoken about, and it was published just last year, 2024, in the month of October. And so we can see that the Faculty of Law, Olabisi Onabanjo University, has actually been working in line with its mission, and that is to teach and also to research and also to be able to give back to the society with cutting-edge research, deep-rooted problem-solving our skills, and all that we endeavor to do. We want to thank you again for coming. This section you see some display by the Public Law Department in respect of the publication. Some of them have been showcased here, and so we say thank you very much for coming to join us. Comments are welcome. Thank you once again.